Hi there. Welcome to Small Business Coffee Break, the video series where we take a few minutes to work on your business, not just in it. Today we talk with Jeffrey Daitz of Hall Booth Smith PC about what are overtime violations and misclassification of exempt employees. Jeffrey has over 20 years of experience in labor and employment law, so grab a cup of coffee and let's get into it. Questions I know when I'm talking to customers specifically about the insurance that I get a lot of, because there's almost always a sublimit here in South Florida, is wage and hour. What is wage and hour, and is it a problem in Florida?
In Florida, it is a huge problem. So the influx of federal court litigation in Florida, in large part, is heavily entrenched with wage and hour class action litigation cases. These are the overtime violations. These are the misclassification of employees. These are not paying on meal breaks. This is somebody that has, let's just say, two businesses. Two separate businesses, but the employees in one business are also working at the other business. You're putting 20 hours in here, you're putting 30 hours in here. Are you treating them as 20 hours for this one, 30 hours of this, or is it combined to be 50 hours? The answer is combined, arguably, to be 50 hours. Now you have an overtime violation. Some people don't understand that. Also, a lot of times people misclassify managers. They think that somebody is an independent contractor when they're not. They put somebody as a bona fide exempt employee under the Fair Labor Standards Act when they're not. And the problem with this is these litigations carry attorney fees, they carry statutory interest, they carry penalties. If these issues are investigated by the Department of Labor, there's look-back periods in terms of how far back the government can look into your files, your record keeping, and documentation. So this is a very big area, and I know that having a presence in the Florida area, we see these cases all the time. And unfortunately, again, it comes down to the education. People, industry specific, don't get it, whether it's construction, whether it's restaurant, retail, hospitality. People, again, need the education. They need to understand what they're doing wrong. Overtime violations are also a lot of times spelled out in the handbook. The misclassification of employees in the handbook. You might inherently be creating a policy that is in and of itself illegal, that a Department of Labor or a plaintiff's lawyer looking to file suit under Fair Labor Standards Act case, you're giving them all the ammunition that they possibly need.
So when we're talking about misclassifying employees and we're talking about exempt and not exempt, what does that mean?
It means there's bona fide exemptions for managers. So let's just say the classic is somebody trying to classify somebody as a manager. You're working for my company, I classify you as a manager so that you don't have to receive overtime. So you're exempt from overtime. But in reality, you don't fit within the landscape of what a bona fide exempt manager or employee might be. So if you don't fall within that landscape, I've misclassified you. In order to recalculate what your numbers are, what your actual hourly rate is, you got to back into all your numbers, find out what a real true hourly wage rate would be for you. So it would destroy the exemptions. You wouldn't be exempt. You would be a non-exempt employee, now subject to the overtime laws.
So even though you may have classified them as an exempt employee, which means they're exempt from overtime, that because of the misclassification now, you're going to try to backwards work, and they're going to start saying, well, hey, I've been working 60 hours a week, and you weren't paying me for it.
And now let's look back over the past couple of years and see what does that really amount to.
And that's when those numbers get really big, right? Because it's not about oh, hey, I just did it this one time, these 2 weeks. It's how often did it happen and how much you can prove happened over the past, or they could prove happened over the past.
And what you just said is key, what they can prove. A lot of times, employees, for instance, if they're classifying you as exempt, right, saying you're a manager and exempt, they're not going to have record keeping because they're not going to have punch in, punch out. They're not going to have anything that's going to document anything other than you being an exempt manager, whereas you can work 60 hours a week or 80 hours a week. It's not going to matter. So they're not going to be able to have as a defense records are going to be able to show anything else. Mm-hmm. So the burden is against whom? The employer.
Right.
So the employer's failure to be able to produce documentation in support of the fact that the person is or is not exempt falls on the side of the employee, in favor of the employee.
Now, if you have any questions that you'd like to ask Jeffrey, I put his contact information in the description. If you have any questions you'd like me to ask Jeffrey or any other professional in their field, my contact information is also in the description. See you next week for another cup of coffee and more questions answered.